Members, this is the appointed time and we have a quorum, so I call this meeting to order. Let's invite the administration to come in. Right, declaration of interest. I need to ask members whether there are any interest to declare. If not, then I need to declare my interest. I am a member of the Board of Directors of the Chinese Medicine Hospital of Baptist University, but I am in no way financially affiliated. We're joined by Mr. Sam Hui, Deputy Secretary for Health from the administration, Dr. Chang Wai-lun, Dr. Vincent Chung, and Mr. Dominic Ho, as well as Mr. Choi Tin Yao. We'll now discuss the policy issues relating to the bill. This is a technical legislative proposal. But before we start our deliberations, I need to ask members whether we need to invite written views from the public or hold a public hearing. If the answer is in the affirmative, a notice will be published on LegCo's website and the views received will be passed on to the administration for a consolidated response. Dr. Teck Chi Yuen, I think people in Hong Kong are concerned about the development of Chinese medicine in Hong Kong. Well, since this bill is rather straightforward and technical, I suggest that we just invite written views from the public. Mr. Lee Chen-kang. Yes, I agree with Dr. Teck Chi Yuen that basically there is consensus in society for the Chinese Medicine Hospital to be established. So I think for any issues arising from the bill, written views should suffice. So if members agree, we will invite the public to write in. We now begin our discussion of the bill. Members, if you have questions, please press the request to speak button. Let me also ask the administration to introduce the bill to members. Thank you, Chair, members. Good afternoon. The government has been committed to promote the comprehensive, high quality and high level development of Chinese medicine. In Policy Address 2014, the government announced setting up a Chinese medicine hospital at a site reserved in Tseung Kwan O. In the 2018 Policy Address, the government further announced that Chinese medicine will be incorporated into the healthcare system in Hong Kong through government subsidies. By the end of this year, the Chinese Medicine Hospital of Hong Kong will commence its operation in phases, and it is an important milestone. As the flagship CM institution, it carries 5 major missions, including healthcare services, education, training, research development, multi-party collaboration. We will also be the change driver. That means the CMHHK will collaborate with the counterparts in the Greater Bay Area and the international community. The government will fully subsidize or fully fund the establishment of the CMHHK, and we will also adopt a public-private partnership model. In 2021, we engaged the Hong Kong Baptist University as the contractor. The service deed was then made out. The Baptist University CMHHK Limited was then set up with an operating period of 10 years, followed by possible 5-year extension. The CMHHK is a Chinese medicine-led hospital. It also provides integration of Chinese and Western medicine. It provides primary, secondary, and tertiary medical services. It also provides inpatient and outpatient services, together with social or outreach services. The operator will also provide government subsidized Chinese medicine services up to 50 to 60% of a level of subsidy. The Chinese Medicine Hospital of Hong Kong will be established and built by the government. It will also be supervised by the Health Bureau. However, it's not a public hospital under the Hospital Authority Ordinance. That's CAP 113. Neither is it a private healthcare facility under the Private Healthcare Facilities Ordinance. Under the existing provision, under the existing laws of Hong Kong, the two ordinances I mentioned only cover public hospitals and private healthcare facilities. To allow smooth operation of the Chinese Medicine Hospital of Hong Kong and for it to provide services, we need to put forward this bill to take forward legislative amendments that are technical in nature, so that for some particular provisions applicable normally to a public hospital or private healthcare facility, they should also apply to the Chinese Medicine Hospital of Hong Kong. These provisions involve employment matters, employees' compensations, rights exemptions, defenses, etc. For example, we propose to amend Section 50 or Section 33 of CAP 57 Employment Ordinance to broaden the scope of hospital to cover Chinese Medicine Hospital of Hong Kong, such that for an employee seeking medical consultation from the CMHHK, the sickness allowance and the relevant subsidies will also apply. The next example is CAP 371 Smoking Public Health Ordinance, Section 2, Subsection 1. Again, the definition of hospital will be broadened to cover the CMHHK, such that both indoor and outdoor areas will be designated as non-smoking areas. In order to avoid misappropriation of the title of CMHHK, such that the public may be misled that the clinical services are provided by the CMHHK, the bill provides that this hospital, CMHHK, situated at Park Sing Kok Road in Cheung Kwan O, is to be titled 香港中醫醫院 in Chinese, or Chinese Medicine Hospital of Hong Kong. We also only allow exclusive use of this title by the proposed hospital. Anyone who used the title without authorization or have unauthorized association by certain means will be subject to criminal sanctions, and that means a level 3 fine or 10,000 Hong Kong dollars. This is a major breakthrough for the development of Chinese medicine in Hong Kong. In view of more such services to be provided by similar organizations, the government will draw up a set of long-term and appropriate regulatory frameworks based on the practical experience of the CMHHK upon commissioning. The government has put in place the relevant supervision mechanism, such as the regime for allowing the operation of the hospital and the drawing up of the service deed. There are also other matters covered, such as governance and risk management to ensure the quality of services of the CMHHK and patient safety. But as transitional arrangements, the government also proposes some necessary technical amendments to 17 pieces of legislation so that the CMHHK enjoys similar treatment on a par with the public hospitals and private healthcare facilities. In October 2024, the Health Bureau consulted the panel on health services, and we have the members' general support to ensure smooth commissioning and delivery of services by the CMHHK, so that it is necessary for this hospital to receive a similar treatment as other hospitals to provide quality Chinese medicine services. And this is a technical bill. I urge members to support us. We'll be happy to take questions and comments from members. Thank you. All right, the floor is now open. Let me read out the names of members waiting. Tang Fei, Tik Chi Yun, Benson Lok, Li Chun Kang, Chen Xiu Hong, Lam So Wai, Yim Kong, Hui Simon Lee, and myself. I'll give each member 4 minutes question and answer, please. Mr. Tang Fei. Thank you, Chairman. I, of course, support the development of Chinese medicine. It was not widely accepted, but 20 years on, with the hard efforts of the SAR government, is now more widely accepted by the public. My question is that according to the paper, this is a CM-led hospital with the supplementary support of Western medicine. Now, in the case of a medical issue or incident where there is a conflict, how should we delineate the responsibilities between Chinese medical practitioners and Western doctors? Can you say more about how the Western medicine would support the running of this hospital? Are you referring to, say, diagnostic services such as CT scans, X-rays, or is it that this hospital may also provide the Western medicine-based operations and prescriptions? Now my last question is this. I think Chang Guan-o is quite far away. So unless this Chinese medical doctor is really famous, I won't travel so far as to Chang Guan-o or even across the boundary. I would just go to a Chinese doctor somewhere nearby in my neighborhood. So you need to explain to the public how CMHHK will be attractive to members of the public, since it's quite remote. I'll give the floor to Dr. Chen. Basically, on integration of Chinese and Western medicine, this hospital will deliver service through the operator. There are different teams. Apart from Chinese and Western medicine, we also have pharmacists and other allied health professionals, and they provide services according to the relevant guidelines. Each team of professionals will be responsible for their own purviews. But basically, since this is a Chinese medicine hospital, the Chinese medicine will be the predominant mode of service delivery. And in the event that a Western doctor is needed, there will be a joint consultation session so as to draw up a treatment plan for the patient. Sometimes allied health professionals may be involved, such as physiotherapists, etc. And the same principle applies. They will join hands in providing treatment to the patients, only that each will be responsible for their own purview. Now, how does Western medicine support the running of a Chinese medicine hospital? Say this is a CM-led hospital. It means that if just by deploying Chinese medicine this patient can be treated, then Chinese medicine will take up the predominant role. If, however, there is a need for the participation of a Western medical practitioner, then this physician will be asked to join in the consultation process and to draw up a treatment plan together. What's more important is to have integration of both and collaboration of both. That means for some specific conditions, they will set out a clinical path together, and that there will be steps for the Chinese medical practitioners to go through, and vice versa. That's a kind of collaboration. They work as a team. What's attractive about this CMHHK is that it is not a typical clinic in terms of the provision of facilities, treatments, and the capacity to handle complex conditions. So of course we will publicize the hospital to raise public awareness. We will also highlight the services to be provided by the CMHHK. We will also work with the sector for more referrals to be made.
Thank you, Dr. Chen. Chairman, I'd like to add one more point. This is a case come up by the people, not myself. What if when a malicious tumor exists in a patient's body and CT scan is necessary, and the Western medical doctor would recommend surgery? But as a Chinese medical practitioners don't do surgery, should we leave it up to the patient to choose to allow them to have the tumor removed by the Western doctor? Should we leave it up to the patient? I think there's a problem here. I think that we can talk about this in our working group meeting, because here we're talking about the bill. Next, Dr. Sik Chi-yin. The establishment of the CMHHK is a great thing for Hong Kong. We want quality Chinese medicine services. And this will also be positive for local training. There are many technical amendments under this bill to incorporate CMHHK in various enactments, so I support the bill. But I have some policy questions in relation to the charges of the hospital. It is mentioned in the paper that the CMHHK will be both public and private. 50% of it will be privately run, and 50% of it will be subsidized by the government. What is the fees charged by non-subsidized services? I wonder how much the government is going to subsidize the hospital, what criteria they adopt to come up with the fee level. I'm worried that if patients find it cheaper to go for Western medicine, then this will undermine the CMHHK and patients will be driven away from the relevant Chinese medicine services. Second, I think that the hospital should at least recover the costs for the part where they have to be privately run. What happens if the CMHHK sustain a loss? We do see that some private hospitals sustaining fiscal deficit. So what happens when this CMHHK sustains a loss in their operation? Third, the government is going to build this hospital. I wonder if the hospital has the liability to return the cost of construction to the government, because part of it is to be self-financed. Dr. Chen, simple answer, please. Thank you. There are two parts to the member's question. Well, first of all, the hospital is going to offer subsidized services to the general members of the public. This reflects the government's commitment to people's health. At the initial stage, 2/3 of the services offered will be subsidized services. 1/3 of it would be non-subsidized services. For the subsidized service, the fee will be charged and the level of it will be determined by the government. For the non-subsidized service, the charge will be determined by the hospital. The key mission of the hospital is to promote the Chinese medicine development in Hong Kong and to integrate into the Greater Bay Area and to bring the Chinese medicine global. We don't have that many service quotas for outpatient services. So the hospital will be a change driver to promote the development of Chinese medicine services, and hopefully the hospital will train talents and to upgrade the role of the Chinese medicine in Hong Kong as a whole. As mentioned, the government and the hospital will decide on the fee level. The charges will be affordable. For the non-subsidized service, we have to take into account the market conditions. Say, for example, for these kind of service that we want to market in the private market, then we need to make sure that the fee charged will allow us to recover a cost. Now, on cost appropriation or apportionment, we look at the finance of the hospital as a whole. We don't adopt a cost recovery principle. The most important thing is that the hospital fulfill its mission to promote the development of Chinese medicine services. So the government has a role to play here. We're going to subsidize or fund the subsidized services, and that account for 2/3 of the services offered by the hospital, and the government is also going to fund training and innovation as well as research. So the government actually shoulder 75% of the financial commitment. We shouldn't be talking about a profit making here. The most important thing is people's health. Our goal is not to be self-sustainable. The most important thing is that the operator, that is the Hong Kong BU, and the government work together to make sure that the hospital will be here over the long run. As long as the finance of the hospital is healthy, when there's a fiscal deficit, the hospital, the Hong Kong BU, and the government will work together to rectify any problem. Next, Mr. Benson Look. Thank you, Chairman. I believe that this is one of the greatest policies under this term of the government. We must do this right. Although under this bill, there are many technical amendments, but I believe that people are concerned about the fee level and the services offered. And I was told that the fee level will be published in September. But in terms of waiting time, in terms of specialist or outpatient services, I believe that there will be a charge of function to be played by the CMHHK here. CMHHK is going to offer outpatient services, obstetricity, gynecology, internal medicine, acupuncture. Now, the CMHHK is going to be situated in the Kowloon East cluster in Tseung Kwan O. Now, in terms of orthopedics and pediatricians, the waiting time is 53 weeks. That's over a year. For pediatricians, patients have to wait 32 weeks. That's the longest in Hong Kong. After the commissioning of the Chinese Medicine Hospital, we believe that many patients will go for the CMHHK instead. Will there be a performance pledge for patients seeking specialized services? What is the recruitment progress for specialist Chinese medical practitioners? In December, the hospital is going to be commissioned, and we're going to have the peak season of the influenza during that time, and we will usually see a surge in the number of outpatient patients. And say in 2024, during the peak season, people have to wait 8 hours, and the occupancy rate of beds is 130%. So we will foresee a huge surge in the demand for outpatient service. So is the hospital prepared to cope with such demand during the peak season for influenza? Thank you. Well, the CMHHK does not operate on its own. It's going to work with the 18 Chinese medicine clinics, training and research centers in 18 districts. We cannot rely on the hospital itself because even with its full commissioning, it only offers some 400 beds. Even with outpatient clinics, it may be able to serve some 12 to 13,000 patients. If all the specialties work together, then we'll be able to serve more patients. Also, we hope that the clinics and the private sector will work with the hospital to cope with the demand, and we actually gauge their support in the establishment of the hospital. Second, on how the patients choose which hospital to go to. Well, the most important thing is that we need to let people know how the CMHHK is going to help them so that they can make an informed decision as to whether they should choose Chinese or Western medicine. Second, we need to let the medical service provider know the type of service available in the CMHHK so that they can make referrals. Can the CMHHK solve the problems faced by the hospital authority? Absolutely not, but it can alleviate the problem. We are still recruiting Chinese medical practitioners. We do have a pool of talent. We have received over 200 applications. So we don't lack Chinese medical practitioners for the hospital. Both experts from both Hong Kong and the mainland will be able to serve in the hospital. In the first year of its commissioning, we don't believe that we need a lot of talents in the hospital. Chairman, I was asking if there's a performance pledge on the waiting time. Well, it's a demand-supply problem. So we have to look at how people use the hospital after its commissioning. We don't have estimates as of right now. Mr. Lee Chen-kang. Thank you, Chairman. Before the COVID, people have been aware of the effectiveness of Chinese medicine treatment, so they are glad to see the establishment of the CMHHK and the service to be available. I have a few questions. First, Chinese medicine hospital is not unique to Hong Kong. There are many similar hospitals on the mainland. So I wonder if we have made reference to similar hospitals on the mainland. Second, Chinese and Western medicine aside, let's talk about doctor and medicine. We have a lot of herbs and herbal powder in Chinese medicine. Are we going to leverage on AI or robotics? Or are we going to have a Chinese medical pharmacist to handle this? Are we going to have enrolled nurse, registered nurse at the hospital? Third, I'd like to ask about equipment. I know that the hospital is going to offer acupuncture, and sometimes electricity is involved. Patients have no rights to choose a doctor, and there could be different treatments given by different doctors. Some of them may use acupuncture with electricity, some may choose to use acupuncture without. How should we deal with this problem? Lastly, people make an appointment via HA Go very often. Are we going to offer similar programs for the same HHK?
I think Mr. Lee has digressed, so let me remind other members to refrain from digressing from the bill. Right, in the interest of time, Dr. Zhang, would you please very briefly answer members' questions? We want to save more time so that we can focus on matters really relating to the bill. So, Dr. Zhang, please try to answer this question. If not, you can take it up with Mr. Lee on other occasions. Well, I think the focus is that they work as a team, be it Chinese or Western medical practitioners. They are all professionals, and they collaborate with each other in devising a treatment plan for patients. It's important to have continuity. Let's say you have this Chinese doctor seeing this patient, and then since the plan has been laid, next time the Chinese doctor will also check for the patient's latest condition and follow on with the plan. In terms of technology, we are a smart hospital. We use computer systems to handle a lot of things, including prescriptions. We also have an autonomous process in preparing the prescriptions. We use machines. Now, in terms of nurses, we have only registered nurses in Hong Kong. In due course, we'll roll out short-term training for nurses to support the operation of the CMHHK. All right, perhaps I'll stop here. Thank you, Dr. Zhang. Next, Mr. Chen Siu-Hong. Thank you, Chairman. The Chinese Medicine Hospital of Hong Kong will be commissioned in the end of this year in phases to deliver services to the public. What's unique about this hospital is that the government funds the construction of the hospital. The Health Bureau will be directly overseeing and managing this hospital, and that an operator or contractor, that is the Hong Kong BU Chinese Medicine Hospital Limited, will be responsible for its operation. Now, this hospital does not fall under the meaning of public hospitals under Cap 113 Hospital Authority Ordinance, nor is it a private healthcare facility under Cap 633 of Private Healthcare Facilities Ordinance. That is why a bill is needed to plug the gaps, and there are also technical amendments in relation to relevant pieces of legislation to deal with sickness in the workplace and injuries on duty, so that those staying in the CMHHK will only pay a fee comparable to the fees and charges in the public healthcare system. I support this bill. I suppose during the panel discussion, members already asked about the fees and the scope of services. At this stage, I think we should focus on the bill itself. What kind of institution is the Chinese Medicine Hospital of Hong Kong? I'd like to seek clarification from the administration. Is it an entity incorporated under Cap 622 of the company's ordinance? The answer is in the negative. Well, it is a limited company, or company limited by guarantee. But what exactly is the Chinese Medicine Hospital of Hong Kong? Is it something like the hardware fully funded by the government, like maternal child care centers? And then its operation is undertaken by a third party? Whether it comes directly under the management of the Department of Health or the Baptist University of Hong Kong, I need to be clear about the status of the CMHHK, because when we come to the clause-by-clause scrutiny, there is a provision on unauthorized use of the title. So I'd like to clarify exactly the status of the Chinese Medicine Hospital of Hong Kong as an entity. Yes, thank you. As mentioned, this CMHHK is the wholly owned property of the government. It is directly managed by the Department of Health, such as the DH-operated clinics. They're similar in nature, but what's unique about this hospital is that it's a body corporate and it's operated by an operator as an incorporated entity. So the legal liabilities will be undertaken by the operator in terms of the day-to-day operation of the hospital. But in terms of the delivery of services as a healthcare institution, it reports directly to the Health Bureau. So in the event of a medical incident or medical blunder, ultimately this hospital is accountable to the Health Bureau. Only that at the policy level or the operational level, it is managed by a body corporate. Chairman, if I may, very briefly, at the district level, we have the maternal child health centers, and they are similar in nature. The difference is that this hospital is to be operated by a third party. But I am not clear why this bill contains a provision on unauthorized use of title of the hospital. Similarly, if we're talking about maternal child health center, there could be an unauthorized use of this center, the title of the center as well. So why should we have an express provision here to ban the unauthorized use of this title? Is it because of the experience in another place, and that there is a false claim of an institution being a government-run institution leading to losses incurred by the public? Or do you think that comparing to the maternal child health center, this unauthorized use could lead to greater losses? Or to answer your question very shortly, the CM-led hospital providing Chinese medicine services is something new in Hong Kong. It's different in nature from the public healthcare facilities provided by and operated by the government. For the latter, we don't envisage a high risk of the name being misappropriated, whereas for the CMHHK, we are worried that some market players in the private sector may in some way try to mislead members of the public into thinking that their operation is somewhat related to the Chinese Medicine Hospital of Hong Kong, as this is the new flagship Chinese medicine institution in Hong Kong. We believe that a preventive approach should be taken to provide guardrails, and that is why we want to provide an express section here. Well, I will come to that during the clause-by-clause scrutiny stage, but very briefly, for the unauthorized use of title, you don't have a similar provision for the HA ordinance, not for the eye hospital, the children's hospital. So if you think that additional guardrail should be provided for the Chinese Medicine Hospital of Hong Kong, then for other special hospitals in Hong Kong, you need to provide similar guardrails as well. Ms. Connie Lam. Thank you, Chair. The CMHHK will be commissioned in the end of this year. This can certainly drive the development of Chinese medicine in Hong Kong and in the Greater Bay Area. As mentioned by other members, when it comes to Chinese medicine, the purpose is to take a preventive approach in its treatment and palliative care for terminal illnesses. Now, the mission of the CMHHK is to generate or create value. As I understand, for this Chinese medicine in Cheung Kwan O, it will take a science-based approach in research and development of PCM, proprietary Chinese medicine. It will also broaden the scope of application of clinical PCMs. So, as this hospital will help the development of Chinese medicine scale new heights, I want to know whether there is a registration mechanism. Is there a database for people to know more about the R&D activities of the hospital? I think this is a matter close to the heart of the public because when it comes to proprietary Chinese medicine, you can buy it over the counter. So, in terms of supervision and what I mentioned, is there anything you can tell the public? The other point is about herbal medicine. I believe that this hospital will be in possession of Chinese herbal medicine. And we also have dried seafood stores, Chinese medical clinics, Chinese medicine pharmacies, etc. In terms of quality assurance and testing, will there be any improvement with the commissioning of the CMHHK? Although we have the Hong Kong Standard of Chinese Material Medica, I'd like to know whether in terms of this bill there will be any further development. I think members are in general concerned about Chinese medicine's development, but still I think for the purpose of this Bills Committee we should focus on this bill. Just very briefly, Dr. Zhang, would you like to answer the member's question on creating value for the sector? The hospital comes with a clinical trial center. That means they can test newly developed Chinese medicine. But to turn it into a proprietary Chinese medicine, we need to go through a series of tests and prepare all the necessary empirical data to prove the efficacy of the medicine. The second point is promotion, and that is about application of Chinese medicine to improve people's health. About Chinese herbal medicine and PCM, I'll give the floor to Dominic. Well, we have a registration mechanism in Hong Kong for PCM. The member's question was on further promotion of the PCM. One of the missions of the hospital is R&D, and we have a clinical trial center to help research PCMs. The other point is about the standards, and that's the Hong Kong standard for Chinese medicine. We already set standards for 344 herbal Chinese medicine already. Sorry, but I think your time is up. I think, of course, you can further elaborate your answer, but why don't we save the talk for another policy discussion elsewhere. Next, Mr. Yim Kong. Well, it's common knowledge that in Hong Kong, every body corporate is free to choose its name. We take a very liberal approach in this bill. I see some guardrails put in place, and that the CMHHK is reserved for the exclusive use as a title for this hospital. Now, upon passage of the bill, I suppose there will be implications on other body corporates which intends to register with a similar title. Say, if you just go on Google and do a search, you will find that there are similar titles such as Hong Kong SAR Chinese Medicine Hospital, and this can create some sort of association.
Deputy Secretary. We ban possible association by a certain other means with the CMHHK. We don't ban it, but the relevant body corporate have to obtain consent from the Secretary of Health. We'll look at the situation after the bill's passed. Dr. Hui Sawan Lee. Thank you, Chairman. I'd like to ask about the Chinese herbal medicine. I know that we're going to have a clinical trial center in the hospital. It's costly to ensure the quality of herbal medicine. And I know that this clinical trial center is going to develop new proprietary Chinese medicine. I wonder if there is any legal basis for it. Thank you, Chairman. I thank the member for his question. The hospital has 24 beds dedicated to the clinical trial center. Regarding legal basis on clinical trial, we follow the Chinese medicine ordinance. If a clinical trial is to be carried out regarding certain PCMs, there has to be a license. We follow the existing mechanism. The CMHHK is a CM-led hospital, and this is a great foundation for us to develop more PCMs. Will the CMHHK be developing new medicine? The CMHHK is a open hospital, and we work with the 3 Chinese medical schools in Hong Kong. The CMHHK has its own scientific projects, and the relevant projects of the 3 medical schools can also be conducted in the hospital. We're going to develop Hong Kong into an international medical hub, and the clinical trial centers in the hospital can also work with other cities in the Greater Bay Area. Next, Mr. Stanley Lee. Thank you, Chairman. I'm concerned about the development of Chinese medicine. I'm also concerned about the charges of the hospital and the waiting time. Now, coming back to this bill, that is the Chinese Medicine Hospital of Hong Kong bill. Having read the bill, I think that it focuses on the use of the name, the Chinese Medicine Hospital of Hong Kong. For unauthorized use of the title of the Chinese Medicine Hospital of Hong Kong, I have some questions. Although I know that we're going to go for clause-by-clause examination later on, for patients without a family doctor, they rely on the qualifications printed on the exterior wall of the clinics before they decide on whether or not to choose the relevant doctor. Under this bill, if a doctor practice in the CMHHK, can they use the name of the hospital in the clinics that they own? We're going to develop new proprietary Chinese medicine. So similarly, medical practitioners who develop PCMs in the hospital, can they quote the experience outside of the hospital? Thank you. The Chinese Medicine Council has a list of regulations setting out what the Chinese medical practitioners can or cannot do. So all Chinese medical practitioners have to fulfill the regulations set out in the council. Any person who is partnering with the CMHHK or is an employee of the hospital, there will be an agreement signed between the hospital and the relevant person. And there will be a code of practice established in the hospital for honorary consultants or employees directly employed by the hospital. So such agreement would solve the issues that you just raised. Let me give you some more information on why we choose to protect the name CMHHK in particular. The Chinese Medicine Hospital of Hong Kong is a new institution. If it's an operating hospital, then it would have been protected under the law. But as this hospital is a new institution, you cannot protect the name by the existing law. Second, the Chinese Medicine Hospital of Hong Kong, the name of it is not unique. That's why we must protect it under the law. If we don't do so, we cannot really protect the patent of it. Next, Mr. Xiu Ka-fai. Thank you, Chairman. We have public hospitals, we have private hospitals in Hong Kong. Private hospital also use the word hospital. Is there any laws that bar any institutions from using the word hospital? In the two existing ordinances, including the HA ordinance and the private healthcare facility ordinance, no existing hospital would have their name protected under the law. For institutions that use names that are patented, then they will be protected under civil law. But if someone uses a patented title to conduct illegal sale of or trade illegal sale of drugs, then they will have violated the ordinance. But as the words, the Chinese Medicine Hospital of Hong Kong cannot be patented because it's not unique enough. That's why we legislate. For the purpose of protecting the name. We don't have relevant provisions for private hospitals in Hong Kong. So we don't really offer protection for Western hospital. Why is that? We're not protecting the Chinese Medicine Hospital, but the name, the Chinese Medicine Hospital of Hong Kong Bill, and that only applies to the hospital at Passion Kok Road. Let me supplement. There are two mechanisms. First, company registration ordinance. It regulates the registration of company name. They look at if there is repetitions, and there are also other requirements. Second, any institutions claiming to be a hospital need to abide by Cap 633, and the name should be approved by the Department of Health. So not all institutions can claim to be a hospital. Just now, the Deputy Secretary. Well, do you mean that we cannot use the name the Chinese Medicine Hospital or the Chinese Medicine Hospital of Hong Kong? We're referring to the combination, the Chinese Medicine Hospital of Hong Kong, and that's for the exclusive use of the hospital in Pak Shing Kok Road. If someone tried to name the company in a way that people may associate it with the CMHHK, then they would be against the law. If a regular Chinese medicine clinics claim that they are designated clinics under the CMHHK, then they will be against the law as well. Would it be okay if someone claimed their institution's Chinese Medicine Hospital of Kowloon? can they call their institutions Chinese Medicine Hospital of Kowloon? Well, theoretically, they can, but we have to look at how they use the name to see if they are deliberately trying to mislead people. Okay. Is my time up? Chairman, we have high hopes for the CMHHK. Professor Bin is the chancellor of the hospital. So I will stop here. I have no further questions. Is there any other questions? I have one. It's my time. I'm glad to see that both panel and non-panel members are concerned about the development of the Chinese Medicine Hospital. And I'm glad to see this bill tabled today. Hopefully, the hospital can commission by the end of this year. Together with Mr. Yim Kong, we've looked into the name. Under the company registry, we've found some similar names, including a Chinese Medicine Hospital Limited, Chinese Medicine Clinics of Hong Kong SAR, so on and so forth. Just now, the Deputy Secretary said that these institutions may or may not be affected upon passage of the bill. I wonder if the government have any measures to help people differentiate between this hospital and other clinics of similar name. According to the bill, anyone who used the title of the Chinese Medicine Hospital of Hong Kong without authority, they will be fined of level 3, that is $10,000. I wonder how you come up with the fine level. What have you considered, and have you made reference to similar laws in Hong Kong? What happens if someone tries to make profit out by using the name? Because the fine level is so low, people may still find it profitable to use the name without authority. Is the fine level deterrent enough? Thank you. Upon passage of the bill, we're going to send an important message to the public, which is that the CMHHK is located at 1 Passion Cock Road, Tseung Kwan O. This awareness is very important because we didn't have such hospital in the past. And there was no laws prohibiting the use of the name currently. Upon passage of the bill, unauthorized use of the name will be against the law. Second, you said that we have companies with similar names currently. We have to look at, well, the business conducted by these companies to see if they are medical related, and we are going to seek legal advice on how we are going to deal with these companies. We may try to solve the problem with the relevant companies by legal means or non-legal means. We have colleagues from the DOJ. I'm no legal expert myself. If a person, a corporate, violates the law, apart from being fined $10,000, I believe that the court will hand down an order prohibiting the use of the name. If the offender does not comply, then they would be held in contempt of the court. Maybe I will ask Mr. Choi to talk about what legislations we've made reference from.
Thank you, Chair. Clause 2 of the bill is modeled on Section 24 of the Hong Kong UST Ordinance. It provides for unauthorized use of title of the Hong Kong UST. So it's modeled on that provision. Any other questions from the floor? If not, we will begin the clause by clause scrutiny. Members, please refer to the Blue Bill CB bracket 2 276/2025, as well as the marked up copy prepared by our Secretariat, LCCB bracket 3 311/2025 bracket 02. Perhaps we start with the Chinese version of the bill, and we will ask the administration to walk us through the bill. We start with the long title in the Blue Bill. The legal advisor may also raise questions and remind members to pay attention to certain matters in the course. We'll start the clause-by-clause scrutiny. Please turn to C9 of the Blue Bill. The long title provides for 3 objects: prohibit the unauthorized use of the title of and the unauthorized association by certain other means with the Chinese Medicine Hospital of Hong Kong. So that's the first one. To amend certain provisions in various enactments so that the Chinese Medicine Hospital of Hong Kong is covered by those provisions. The third one is to make a related amendment. Oh, please pause here, Ms. Connie Lam. Thank you, Chair. Prohibit the unauthorized use of the title of and the unauthorized association by certain other means with the CMHHK. Can you tell us what is meant by other means, certain other means? The bill does not explicitly provide what other means refer to, but basically, if a body corporate with reference to the title CMHHK is set up, or if a person takes up the position as a, say, a board director, then he may be in breach. We will explain further in clause 2. Chairman, but the point is too vague here. There is no specific description. I'd like to see if there is a footnote, perhaps, to set out the scope, or perhaps you should set out the conditions for elucidation. Dr. Zhang. Now we keep the expression here, certain other means. We keep it non-exhaustive because there are creative people in the business who may resort to other means not on your list to exploit this title. So we need to consider on a case-by-case basis, be it a shop sign or something in an electronic form or a pamphlet. We need to have regard to the actual circumstances before determining whether this bill or this provision has been breached, whether an unauthorized association has been made. Legal advisor. Now, to answer members' question, this is the long title. Long title sets out the object of the bill, so inevitably it's vague. For the actual effect of the provisions, you need to go to the actual provisions. Mr. Michael Lee. To pick up on what Ms. Connie Lam said, even if no specific notes are provided here, will there be a code of practice that sets out what it means? Because the Baptist University will be the operator of this hospital. Can I also claim to be a member of the hospital, or is it that it will be in breach of this rule against self-advertisement? Now, let me give you an example. 15 years after its commissioning, the hospital will not be operated by the Hong Kong BU, and if there is a continuous claim of association with the CMHHK, then it will be in breach of the law. But of course, the title can be legitimately used as long as the description does not involve the status as an operator. And that depends on the context, whether the description misleads members of the public into believing that unauthorized association. Now, about the scenario you mentioned, 15 years down the road, perhaps you should improve the drafting to avoid misleading the public. Say, if this happens in the future, the operator should use certain titles or descriptions instead. But I think it's difficult to give an exhaustive list in the law. It all boils down to the merits and the evidence in each and every case. We also need to decide on the context, because we're talking about the criminal offense. It is not possible to include an exhaustive list of every scenario in just a single provision. Right, moving on to Clause 1, short title. This ordinance may be cited as the Chinese Medicine Hospital of Hong Kong Ordinance. Alright, please go on. Clause 2, Subclause 1. For the purposes of this section, it provides for a definition. A body of persons falls within the description if it is a body of persons, whether corporate or unincorporated, that purports or holds itself out to be the HHK or any part of it, or to be in any way associated with that hospital, uses the title the Chinese Medicine Hospital of Hong Kong, or 香港中医醫院 in Chinese, uses the title in any language that closely resembles the title of CMHHK or 香港中醫醫院 in Chinese, has to be capable of misleading any person into believing that the body of persons is the CMHHK or any part of it, or is in any way associated with that hospital. Subclause 2. That's an example. A person must not, without written consent of the Secretary, incorporate or otherwise form a body of persons that falls within the specified description. Please pause here. We have a question from the floor. Mr. Chen Xiu-Hong. Thank you, Chair. My question is on Clause 1, Subclause 2. And I also have a question on Subclause 3. But let me start with Subclause 2. A person must not, without written consent of a Secretary, incorporate or otherwise form a body of persons that falls within the specified description. Now, including Chairman, a number of members just now mentioned some incorporated bodies even before passage of the bill, such as the so-called Hong Kong SAR, Chinese Medicine Hospital, etc. Now, if there are already entities using a similar title as a CMHHK in existence before passage of the bill, my question for the administration is that when this bill is passed and when this clause comes into effect, and that is if the entities using a title that closely resembles the title of CMHHK, then does it mean that a written consent from the Secretary should be sought? Or is it a defense because the body has already been incorporated before the passage of the bill? Because this is something in the past tense, this entity already existed before passage of the bill, then how are you going to deal with these body corporates? Thank you, member, for the question. The offense does not have any retrospective effect. If you go to Subclause 3, without written consent of the Secretary, this person must not hold the office of director or any other office of, so on and so forth. That means this person must not work in connection with this body of persons. So apart from not using the title, this person must not be a director of that body of persons. What I mean is, before the bill has been passed, this person is already the director of this body of persons. In accordance with the Companies Ordinance or other laws of Hong Kong, this is entirely legitimate. And on what grounds can you hold this person accountable, accusing this person of breaching the law before the passage of the bill? If this person is a director before the bill comes into effect, then it's not an offense. It's only when the bill takes effect that this person knowingly continues to be a director of this body of persons that he may be in breach of this provision. Well, let me explain how this clause operates. As Mr. Chan suggests, there are bodies of persons already incorporated before passage of the bill, and this body corporate may be using a title that may cause some sort of association with a CMHHK. Then, like my colleague said, in theory, the person must not be a director of this body corporate. But we're not suggesting that the body corporate itself will become illegitimate instantly, because as we explained, before commissioning of the CMHHK, we need to, first of all, find out how many bodies there are using similar titles, and we need to conduct an assessment to see whether the public will be misled because of it. And to err on the side of caution, if the body corporate is doubtful about the use of title, then a written consent should be sought from the secretary to continue with the operation of its entity. And then we will consider the matter on a case-by-case basis. But if after passage of the bill there is a body corporate that adopts this misleading title, then we need to request for a change of the body corporate's title. Chairman, this is very important. As far as the common law is concerned, I have been operating legally, legitimately, and if another piece of legislation comes into operation that affects my legitimate operation, then that's another matter. Using this as an example, before the bill has been passed, I'm allowed to use this title and be the director of this company. And then when the bill is passed, a written consent should be sought before I continue with the operation. And naturally, the directors must resign immediately. The directors of a company have this fiduciary duty. That means in the event of the company's winding up, for the transfer of assets, a director must be engaged, at least for signing off the transfer or the financial statements for the auditor. So it seems to be a rather straightforward point, but what stems from it could be something really complex. Well, this may be just a hypothetical question. I don't know whether a company at the moment is using this misleading title as the Hong Kong SAR Chinese Medicine Hospital. But if this hypothesis is true, then it could spark some controversies. So if need be, you should provide a note or some guidelines here. The DOJ should go back and consider the loophole here.
忽發奇想
Ms. Lam So Wai. Thank you, Chairman. For existing companies and institutions, if they have a name that is similar to CMHHK upon passage of the bill, what happens if someone registers the name, say, Chinese Medicine Center of Hong Kong? Will such registration be barred because this may mislead consumers? I think that Dr. Chen has already answered this question under the existing framework. There are two levels to registrations of name. After the CMHHK has become a proper name, and as CMHHK is a registered property, if someone tries to register a company with a name that is similar to CMHHK, the company registry will decide on whether the name will be granted to that particular company applicant. That's the first level. Second, we've talked about the protection of the name CMHK under the law. So upon passage of the bill, if an entity tried to change the name to, say, a Chinese Medicine Center of Hong Kong, then they should obtain the Secretary of Health approval before they can use the name. Chairman, you gave an example of, say, the Hong Kong SAR Chinese Medicine Clinics. That is an existing company. Some people who try to seek Chinese medicine services in Hong Kong from other countries may confuse the SAR Chinese Medicine Clinics with the CMHHK. Will you ask the existing clinics to change their names? Will you force them to change their names? Thank you. If a company try to associate them with Hong Kong SAR in the names, then the company registry will not grant such name to the company. The company registry has a set of regulations as to whether a name may mislead a potential user. Say, for example, if the entity used the CMHHK directly, then they will have to obtain consent from the secretary to use the name. But if the name is not a direct copy, then we have to look at the details to see if they, say, for example, claim to be a dedicated clinics under the CMHHK. If they have an intent to mislead people, then we can invoke regulations under the company's registry. Next, Mr. Lee Chen-kang. Thank you, Chairman. Let's not talk about existing names. When I look up the internet, I see that there is a Hong Kong SAR Chinese Medicine Clinics. It's possible that this company is registered under another name with the company registry. Will you allow such form of promotion and marketing? Just as was Ms. Connie Lam asked, are you going to force the existing companies to change their name if they don't obtain consent from the secretary? A simple answer, please. I have already explained this. We look at each and every case individually. If it is a body corporate and institutions that have already been established, we will look at whether the name of it is in conflict with the CMHHK. This is not a new thing, actually. There are brands and companies that have been in operation for a long time, and when another brand obtain a patent, then that would affect all existing brands and companies in Hong Kong. But for CMHHK, we try to legislate to protect the name because, well, as explained, it's difficult for us to obtain patent protection for the name because it's not unique enough. If we are able to obtain a patent for the name, then no one else could use the name. We're just trying to explicitly state that under the law. Let's refer to subclause 3 of clause 2 of the bill. A person must not, without the written consent of the secretary, hold the office of director or any other office of, be the organizer of, or otherwise work in connection with a body of persons that falls within a specified description, or be a member of such a body of persons. Any questions? If not, please proceed. Subclause 4. A person who contravenes subsections 2 or 3 commits an offense and is liable on conviction to a fine at level 3. Any questions? If not, please proceed. Yes, Mr. Lee Chen-kang. Thank you, Chairman. You also asked about the level 3 fine. Is the government going to review the level of fine regularly? Because I think that the level is too low. Because if the fine is too low, it may be profitable for people to misappropriate the name. The member is correct. If we find that the fine is not deterrent enough, upon passage of the bill, we're going to adjust it. My second question, what about people reoffending? The court decides on the level of fine to be handed down. The fine may not be at level 3. The judge is going to look into the details of the case to see if the person is committing the offense for the first time, along with other factors. Subsection 5. In this section, Secretary means the Secretary of Health. The Chinese Medicine Hospital of Hong Kong, Hong Kong Zhongyi Yiyuan, means the hospital that is known as the Chinese Medicine Hospital of Hong Kong in English and Hong Kong Zhongyi Yiyuan in Chinese, and is situated at 1 Pak Shing Kok Road, Cheung Kong, New Territories. Any questions? If not, please proceed. Let's refer to clause 3 of the bill. Certain enactments amended for covering the Chinese Medicine Hospital of Hong Kong, etc. The enactments are set out in the schedule. Please refer to the marked up copy prepared by the Legal Services Division, that is CB bracket 3311/25 bracket 02. Please refer to the marked up copy too. Let's go to C15 of the bill schedule. We're going to amend Caps 57, Employment Ordinance, Section 33. That's page 9 of the marked up copy. Section 33, bracket 6, bracket A. Well, after it, we're going to add the Chinese Medicine Hospital of Hong Kong as defined by Section 2, bracket 5 of the ordinance. Any questions? If not, please proceed. We can move on to Part 2. Clause 2. We're going to amend Section 2 of Cap 138, Pharmacy and Poisons Ordinance. That's page 17 of the marked up copy. We're going to amend Section 2, bracket 1, definition of institution. After paragraph D, we're going to add paragraph DA and include the Chinese Medicine Hospital of Hong Kong there. Let's proceed to Part 3. We're going to amend Births and Deaths Registration Ordinance, Cap 174, second schedule. We're going to amend second schedule, Form 18, Part 3. After paragraph 2, 16, A, we're going to add a paragraph AB. seeing that if the deceased died in the Chinese Medicine Hospital of Hong Kong. Now we move on to Part 4. We're going to amend Undesirable Medical Advertisements Ordinance Cap 231. That's page 31 of the marked up copy. We're going to amend Section 3. After Section 3, bracket 7, we're going to add a new subsection, which says subsection 1 also does not apply to any publication by the Chinese Medicine Hospital of Hong Kong of information about the prices of chargeable items and services provided in that hospital, or historical statistics on the fees and charges for treatments and procedures provided by the hospital. Any questions? If not, please proceed. Now we can refer to page 32 of the marked up copy. There's another amendment. We're going to amend Section 5. After Section 5, bracket 1, bracket C, bracket 4, we're going to add a bracket 5, the Chinese Medicine Hospital of Hong Kong. Any questions? If not, please proceed. Now we've come to Part 5. We're going to amend Child Care Services Ordinance Cap 243. That's page 34 of the Chinese marked up copy. We are going to amend Section 3. In Section 3, bracket 1, bracket B, bracket 2, we're going to repeal the word or. And after Section 3, bracket 1, bracket B, we're going to add paragraph BA, saying that any child care center situated in the premises of the Chinese Medicine Hospital of Hong Kong. Any questions? If not, please continue. Now we arrive at Part 6. We're going to amend Employees and Compensation Ordinance Cap 282. That's page 35 of the marked up copy. We're going to amend the definition of hospital under Section 3, bracket 1. We're going to repeal the words or any and substitute it with any. And under Section 3, bracket 1, definition of hospital, we're going to add or the Chinese Medicine Hospital of Hong Kong. Any questions? If not, please proceed. Now we've come to Part 7. We're going to amend Dangerous Goods Application and Exemption Regulation 2012 Cap 295 Sub-Legislation E. That's page 52 of the marked up copy. We're going to amend Section 2, definition of medical establishment. After paragraph C, we're going to add subparagraph CA, the Chinese Medicine Hospital of Hong Kong. Any questions? If not, please carry on. Now we can move on to Part 8. We're going to amend subsidiary legislation under Supplementary Medical Professions Ordinance Cap 359, Division 1, Medical Laboratory Technologists Registration and Disciplinary Procedure Regulations Cap 359, Sublege A. We're going to amend Schedule 4 to add Item 12, the Chinese Medicine Hospital of Hong Kong, to exempt the HHB CR from the Supplementary Medical Professions Ordinance. Now we move on to Division 2, Occupational Therapist Registration and Disciplinary Procedure Regulations Cap 359, Sublege 5. We're going to amend Schedule 4. That's page 58 of the marked up copy. We're going to amend Schedule 4 at paragraph 9, the Chinese Medicine Hospital of Hong Kong, to exempt it from Section 20 and 21, bracket 1 of the ordinance. Now we move on to Division 3, Radiographers Registration and Disciplinary Procedure Regulation Cap 359, Sublege H. That's page 61 of the marked up copy. We're going to amend Schedule 5 to introduce Item 12 and exempt the HHB CR from Section 12 and 21, bracket 1. If no questions, please proceed. Now we move on to Division 4. Physiotherapist Registration and Disciplinary Procedure Regulation Cap 359, Sublege J. That's page 64 of the marked up copy. We're going to amend Schedule 4 to add Item 11, the Chinese Medicine Hospital of Hong Kong, to exempt it from the regulation under Section 20 and 21, bracket 1. Any questions? If no, please proceed. Now we can move on to Part 9.
Amending Pneumoconiosis and Mesothelioma Compensation Ordinance Cap 360, marked up copy, page number 67, will amend Section 2 Interpretation Clause in Section 2.1 Definition of Hospital. Will delete or any and replace it with comma any. Also under 2.1, in terms of definition for hospital after public hospital, we will add the Chinese Medicine Hospital of Hong Kong. Any questions? Please go on. Part 10, Smoking Public Health Ordinance, Cap 371. Page 82 of the marked up copy. Section 2 amended interpretation. Section 2.1 definition of hospital. We repeal paragraph B and substitute with a new paragraph. Whether or not it is a public hospital as defined by Section 2.1 of the Hospital Authority Ordinance, Cap 113, or the Chinese Medicine Hospital of Hong Kong as defined by Section 2.5 of the Chinese Medicine Hospital of Hong Kong Ordinance of 2025. No question, please go on. Part 11, Coroner's Ordinance, Cap 504 amended. Page 84 of the marked up copy. Schedule 1 amended. In Schedule 1, Part 1, after paragraph 16a, we add paragraph AB to provide that the deceased died in the Chinese Medicine Hospital of Hong Kong. Part 12, amending Chinese Medicines Regulation Cap 549F, marked up copy page number 86, will amend Section 12. We repeal the semicolon or and substitute a semicolon. For 12I, we repeal force and substitute with force semicolon or, and we also add J after 12I to add the Chinese Medicine Hospital of Hong Kong. No question, please continue. Part 13, Human Reproductive Technology Ordinance, Cap 561, to be amended, page 90 of the marked up copy. Section 15A amended. In the English text, we amend the definition of specified person in 15A9. In the Chinese copy, again, 15.9a, definition of specified person. And then after paragraph B5, we add Roman numeral 6, and that is Chinese Medicine Hospital of Hong Kong. Any question? One more. Lastly, a related amendment in Part 14, Rating Amendment Ordinance 2024-26 of 2024. That's page 91 of the marked up copy. Section 8 amended. A new Section 2B4E in Section 8.3. After Hong Kong, we add the Chinese Medicine Hospital of Hong Kong Ordinance. Mr. Michael Lee. We were going too fast. I'd like to go back to Part 12. Page 86 of the marked up copy. Now, just a drafting point. HI, a hospital or clinic managed or controlled by the HA, etc., and then you delete the word or. Just put a semicolon, and then which a license under the ordinance is in force, and then you add force plus the semicolon, and then you add subpoint J. My point is you should have H before J, H and then J before I, because you should put the public facilities together before moving on to private healthcare facilities. So that means J should come after H because both are publicly run, and then you have I that follows, and that is run by private organizations. Is it more reasonable then? Well, let's see what our legal advisor thinks. Thank you, member, for the suggestion. H is a public hospital. Now, the Chinese Medicine Hospital of Hong Kong provides services, and 2/3 actually government funded. Well, that's the order of things, as you can see in previous sections. So I think that's a better way of drafting.
或者我都試下補充下，多謝。
Let me supplement his answer. Thank you, Chairman. Thank you, Member, for the questions. I think the law draftman can review the order we do not have a specific order. In fact, if you go to page 82, for definition of hospital, it goes like this. It starts with private healthcare facility, and then public hospital, and then Chinese Medicine Hospital of Hong Kong. So we have adopted different orders of things. So still, Chairman, for B it has both, but for A it's for private healthcare facility. Now I'm suggesting that since you are separating the two, why don't you put the CMHHK and public hospitals together? Using page 82, I can give you this excellent example. Why should you separate the two? We can turn to other examples. We have different structures as well. Say for page 52, we have different healthcare facilities and organizations. It goes from A, and then AA, it starts with a private healthcare facility, and then RCGs, etc. Clinics, followed by hospital or clinic managed by HA, and then the Chinese Medicine Hospital of Hong Kong. So it's just the drafting practice. We don't want to make substantial amendments to the existing ordinances themselves. The legal effect should be the same. Remember, let's see if this change is warranted. Is the convention to add a new section at the end of the existing provisions in an amendment bill unless it carries a particular legal meaning. Because otherwise, instead of having HJI, we will need to add HA after H before moving on to I without changing the existing structure. We don't see any necessity in changing the order as it does not carry a special legal meaning. Mr. Lee. Right, no change in the legal effect. It's just how things are ordered. So it's just a drafting suggestion. Right, nothing else. So we've completed the clause-by-clause scrutiny. We've completed the Chinese version. Let me ask a legal advisor if there is any particular issue relating to the English rendition. The legal advisor earlier wrote to the administration and raised some issues, but apart from that, we don't have any other issues to raise. Members, if you want to move an amendment to the bill for our consideration, then please forward any draft amendments to the Secretariat. So do that in writing, please. Members have raised some issues at today's meeting. Would the administration please provide a written response? Depending on the development, this Bills Committee may convene again, but if another meeting is not needed, the Secretariat will discuss with the administration on resumption of second reading of this bill, and a report will be submitted to the House Committee. Anything under AOB? So the meeting is adjourned. Thank you.